So let me pull up here. So I'll kind of go on a tangent off of that. I got a question up here that I think tied really, really closely to this, and it may have been deleted. But basically, the premise of the question was, if you're, say, the targeted parent in terms of you have a protective order against you, walk me through in Pennsylvania. Obviously, we're talking about situations where there's no issues with being wherever you want, whenever you want. Walk us through how the protective order process works in the state of Pennsylvania.
So in the state of Pennsylvania, if someone alleges that they've been abused, you would get a temporary order, possibly. The courts do, I feel they hand the temporary orders out too readily. It can include that a custody provision where you don't see your children. In Pennsylvania, you have to have a hearing within 10 days if someone files for protection from abuse. So that's going to get filed and heard the following week, generally. And at that hearing, the person would have to prove that there's been abuse. If the child is included, a lot of times judges will look to see if this is really a custody issue or not. So if it's a custody issue, the person might get a protection from abuse, but then they'll make it go to custody court regarding the children. But if the child is put on a custody, if the child's put on the protection order, you can still go to family court and file for custody and have it go through the custody court. And the saddest part is when somebody doesn't realize they have that right. So I have had people come in my office, a dad that maybe had a protection order for 2 years and didn't try to pursue any contact with his child for 2 years because he just didn't know that you could go still to custody court and to try to get contact, because the custody order is going to trump the provisions in the protection from abuse order. So it's really important to understand that they're two separate things, and you want to file in that custody court, even if there's a PFA in place. But they are the most abused for custody purposes. So I think the courts are catching on to that, and they're always looking to see, are children involved? Is this really a custody issue? And denying the PFAs if it is a custody issue. But not always. Sometimes the PFA does get entered, and it really was all about custody. It gives someone a leg up to get a jump start on getting custody of their child. So it's really important, if you get hit with a PFA, the other part of it is that you litigate it. Because if you go to court, a lot of times in Pennsylvania, they're going to try to sell you to just take an agreement because it's not criminal, it's just civil. And it's really important that you try your case in Pennsylvania, because a lot of times it's a protection from abuse, is a PFA, but a lot of times they don't have enough evidence. And it does prejudice you. So if children are involved, I would always recommend that, unless you are guilty of violence, that you have a hearing and never just agree to it. Because the problem in court in general is that they try to push agreements instead of hearings because they can't hear every case. But you could really prejudice yourself if you agree to something, because it's sometimes hard to change it in the future. And it sets a precedent.
Yeah. I always tell guys, in family court, the status quo is very, very powerful. And the biggest mistake you can make, whether it be a PFA, we call them domestic violence restraining orders here in California, is to just kind of lay down and be annoyed and be frustrated and not do anything on the custody piece.